Hey friends, hello, how are you? I hope all of you are doing well. Today I am going to teach you a Bare Act topic which is from Criminal Procedure Code, and I am going to talk about chapter 36 of the Criminal Procedure Code, which talks about the limitation for taking cognizance of certain offences. So friends, this chapter is being briefly defined in section 467 of the Indian Criminal Procedure Code, which says that for the purpose of this chapter, unless the context otherwise requires, period of limitation means the time period defined in section 468 for taking cognizance of an offense. So friends, let's see what the section 468 says about this. So section 468 talks about the bar to take cognizance after lapse of the period of limitation, except as otherwise provided elsewhere in this code. No court shall take cognizance of an offence of the category specified in subsection 2 after the expiry of period of limitation. Secondly, the period of limitation shall be 6 months if the offence is punishable with fine only. Secondly, the period of limitation shall be 1 year if the offence is punishable with imprisonment which does not exceed than 1 year. Thirdly, the period of limitation shall be 3 years if the offence is punishable with imprisonment exceeding more than 1 year but not exceeding more than 3 years. For the purpose of this section, the period of limitation in relation to an offence which may be tried together shall be determined with reference to the offence which is punishable with the more severe offence, or as the case may be, the more severe punishment. Now we will talk about the commencement of the period of limitation, which is given in the section 469. So this section says that the period of limitation in relation to the offender shall commence on the date of offence, where the commission of offence was not known to the person aggrieved by the offence or to any police officer. The first day on which such offence comes to the knowledge of such person or to any police officer, or whichever is earlier, or where it is not known by whom the offence is committed, the first day on which the identity of the offender is known to the person who is aggrieved by the offence or to the police officer making the investigation to the offence, whichever is earlier. In computing the said period, the day from which such period is to be computed shall be excluded. Now, we will talk about exclusion of the period in certain cases, which is given in the section 470 of the Indian Criminal Procedure Code. So firstly, it is said that in computing the period of limitation, the time during which any person have been prosecuting due diligence another prosecution, whether in a court of first instance or in a court of appeal or revision against the offender, shall be excluded, provided that no such exclusion shall be made unless and otherwise The prosecution relates to the same facts, provided that no such exclusion shall be made unless the prosecution relates to the same fact and is prosecuted in good faith from the court in which the defect of jurisdiction or other cause of a like nature is unable to entertain it. Secondly, where the institution of the prosecution in respect of an offence had been stayed by an injunction or an order, then in prosecuting the period of limitation and the period of continuance of the injunction or order, the day on which it was issued and made and the day on which it was withdrawn shall be excluded. Thirdly, where the notice of prosecution of an offence has been given or under any law for the time being in force, the previous consent or sanction of the government or any other authority is required for the institution of the prosecution for any offence. Then in computing the period of limitation, period of such notice as the case may be, the time required for obtaining such consent or sanction shall be excluded, such as in computing the time required for obtaining the consent or sanction of the government or any other authority, the date on which the application was made for obtaining the consent or sanction and the date of the receipt of the order of the government or other authority shall both be excluded. Fourthly, in computing the period of limitation, the time during which the offender has been absent from India or any other territory from the outside of India, which is under the administration of the central government or has avoided arrest by absconding or concealing himself, shall be excluded. Now we will talk about section 471 of the Code of Criminal Procedure, which talks about the exclusion of the date on which court is closed. So, where the period of limitation expires on a date on which the court is closed, the court may take cognizance on the date on which the court reopens. Now, in this context, section 472 says about the continuing offense. In the case of a continuing offense, a fresh period of limitation shall begin to run at every moment of time on which the offense continues. Now, section 473 talks about the extension of period of limitation in certain cases. So it says, notwithstanding anything contained in the foregoing provisions of this chapter, any court may take cognizance of an offense after the expiry of period of limitation, if it is satisfied on the fact and in the circumstances that the delay has been properly explained or that it is so necessary to do in the interest of justice. So here this chapter 36 closes, and I hope I have helped you in reading Bare Act. Friends, I make videos because sometimes we don't have time to go through the Bare Act, and if there is any video about the reading of Bare Act, then it will be easy for you to put on your headphone and listen to it at anywhere. So do keep support my channel, and thanks for watching my videos. I will assure you that I will bring some more videos for you so that I could help you in studies. So see you again in next video. Till then, bye bye.